Roberts declared confidently, "Our court is always fair." Jasmine quietly stood up and played the audio recording. Roberts's own voice echoed, "We need to lose this case, or the party will be finished." Roberts's face went white. The Senate Judiciary Committee's oversight hearing on Supreme Court administration had been scheduled as the most routine of governmental rituals, the kind of procedural theater that C-SPAN viewers use to fall asleep and constitutional scholars use to update their CVs. Chief Justice John Roberts had agreed to testify as a matter of institutional courtesy, fully expecting to spend 2 hours delivering platitudes about judicial independence and constitutional interpretation. For the first 90 minutes, it had proceeded exactly as his staff had anticipated. Roberts had masterfully navigated softball questions from Republican senators about the court's workload and administrative efficiency. He had deflected predictable Democratic challenges about ethics reform with practiced ease, his decades of appellate experience evident in every carefully calibrated response. The Supreme Court, Roberts had intoned during one particularly eloquent response to Senator Ted Cruz, represents the pinnacle of American jurisprudence precisely because we remain above the political fray. We serve not the interests of parties or politicians, but the enduring principles of constitutional law. His voice carried the weight of institutional authority as he continued, "Every decision we make is based solely on legal merit, constitutional text, and judicial precedent. Politics, personal relationships, and external pressures have no place in our deliberations." The Republican senators nodded approvingly. This was exactly the kind of testimony that reinforced their narrative of judicial independence and constitutional originalism. Roberts was giving them everything they needed to defend the court against Democratic attacks on its legitimacy and ethical standards. "I want to be absolutely clear about this," Roberts concluded, his tone rising to match the gravity of his office. "Our court is always fair. We approach every case with the same commitment to impartial justice, regardless of which party appointed us or which political interests might benefit from our decisions." The applause from the Republican side was immediate and enthusiastic. Senator Lindsey Graham looked like he had just witnessed the reaffirmation of American democracy itself. But Jasmine Crockett wasn't applauding. She was studying a small digital device that had been hand-delivered to her office just hours before the hearing by someone who had identified themselves only as a friend of constitutional accountability. The device contained audio files that painted a very different picture of how the Supreme Court actually functioned behind its marble facade. "Chief Justice Roberts," Jasmine said, her voice cutting through the settling applause with surgical precision, "I appreciate your stirring testimony about judicial impartiality." Roberts's expression remained composed, but something flickered behind his eyes, a recognition that the tone had shifted in a way he hadn't anticipated. "Thank you, Congresswoman. I have some questions about how those principles applied during your handling of the case Morrison versus Federal Elections Commission in 2020. The case name hit the hearing room like a cold wind. Morrison v. FEC had been one of the most controversial decisions of Roberts's tenure as Chief Justice, a 5-4 ruling that had effectively eliminated most remaining restrictions on corporate political spending. The decision had reshaped American politics in ways that were still being felt 4 years later. Roberts's media training kicked in immediately. "As you know, Congresswoman, I cannot discuss the court's internal deliberations on specific cases. That would compromise the confidentiality essential to our judicial process." "Of course," Jasmine replied, her tone maddeningly neutral. "But I'm not asking about internal deliberations. I'm asking about external communications." The distinction was crucial and ominous. Internal deliberations were protected by centuries of judicial tradition and constitutional separation of powers. External communications, conversations between justices and outside parties about pending cases, were potential evidence of judicial corruption. Roberts tried to maintain his composure, but a note of defensiveness crept into his voice. "I'm not sure what you're suggesting, but Supreme Court justices do not engage in inappropriate communications about pending cases." "I'm sure that's the policy," Jasmine said, lifting the digital device so the cameras could see it clearly. "But I'm more interested in the practice." The device was small but sophisticated professional recording equipment, not a consumer electronics product. Its very presence suggested serious preparation and institutional-level documentation. This, Jasmine continued, contains audio recordings of phone conversations between you and various parties with interests in cases before the Supreme Court. The recordings were made by participants in those conversations as part of their personal record-keeping practices. Roberts's face went very still. Audio recordings of Supreme Court justices discussing pending cases would be constitutional dynamite, evidence of judicial misconduct that could trigger impeachment proceedings and fundamentally alter the balance of American government. I have no idea what you think you have there, Roberts said carefully, but any conversations I may have had would be protected by judicial privilege and... Would they? Jasmine interrupted smoothly. Because according to Supreme Court ethics guidelines that you yourself helped draft, justices are prohibited from discussing pending cases with interested parties regardless of any claimed privilege. She was right, and everyone in the room knew it. The Supreme Court's own ethics rules explicitly prohibited exactly the kind of external communications that Jasmine was suggesting had occurred. Roberts tried a different approach. Even if such recordings existed, which I'm not conceding, they would be inadmissible hearsay and... Chief Justice Roberts, Jasmine said, her voice carrying a prosecutor's authority, we're not in a courtroom. We're in a congressional oversight hearing investigating potential judicial misconduct. Hearsay rules don't apply. The distinction was legally accurate and politically devastating. Roberts couldn't hide behind evidentiary rules or procedural technicalities when Congress was exercising its constitutional oversight authority. Furthermore, Jasmine continued, these recordings were authenticated by FBI forensic analysts and cleared for congressional disclosure under the Judicial Accountability Act. Roberts's mouth opened slightly. The Judicial Accountability Act was recent legislation that had expanded congressional authority to investigate judicial misconduct. If the FBI had authenticated the recordings and deemed them relevant to congressional oversight, Roberts had no legal grounds to prevent their disclosure. Would you like to hear one of these recordings, Chief Justice Roberts? The question hung in the air like a sword of Damocles. Roberts had no good options. Either he agreed to have his private conversations played for the world to hear, or he appeared to be hiding judicial misconduct from congressional oversight. His decades of legal training warred with his political instincts. The lawyer in him wanted to object, to claim privilege, to demand due process. The politician in him understood that such resistance would look like guilt to the millions of Americans watching on television. Roberts chose silence, which Jasmine took as reluctant consent. She connected the device to the hearing room's sound system, the technical setup taking just moments but feeling like an eternity to everyone present. The silence in the room was absolute. Senators, staff members, and reporters all holding their breath, waiting for whatever nuclear revelation was about to be unveiled. The first recording began with a digital timestamp, October 15, 2020, 3:47 p.m. Then came a voice that everyone in the room recognized immediately, the distinctive tone and cadence of Chief Justice John Roberts. Leonard, I wanted to give you a heads up about the Morrison case. Oral arguments are next week, but I think we can discuss the likely outcome. The voice responding was equally recognizable to anyone who followed campaign finance law. Leonard Morrison, CEO of Morrison Industries and the named plaintiff in the case that would bear his name. I appreciate that, John. As you know, this case is critically important to our industry's ability to participate in the political process. I understand completely, came Roberts's voice through the speakers. The constitutional issues are clear-cut. The First Amendment protects corporate speech just as vigorously as individual speech. I'm confident we can craft a majority opinion that provides the clarity you need. The conversation continued for several more minutes, Roberts providing detailed analysis of his colleagues' likely positions, Morrison offering specific examples of how the case outcome would benefit his business operations, both men speaking with the casual familiarity of long-standing business partners rather than the careful distance that should exist between a judge and a litigant. The most damaging exchange came near the end of the recording. John, I hope you know how much we appreciate your leadership on these constitutional issues. Thank you, Leonard. It's important work, and I'm glad we can find ways to support each other's efforts. Speaking of support, I believe we discussed the possibility of expanding our consulting arrangement with your wife's firm. That would be very helpful. These speaking fees and consulting contracts help supplement what is frankly a modest judicial salary. Consider it done. I'll have my people reach out to her directly. When the recording ended, the silence in the hearing room was profound and terrible. This wasn't just inappropriate communication between a judge and a litigant, it was what sounded like systematic corruption, with the Chief Justice of the United States Supreme Court apparently coordinating with parties appearing before his court while discussing financial arrangements for his family. Roberts sat motionless, his face a mask of shock and dawning horror. The institutional authority that had defined his career was crumbling in real time on national television. Jasmine spoke into the silence, her voice quiet but carrying to every corner of the chamber. Chief Justice Roberts, on this recording, you can be heard coordinating with a litigant about the likely outcome of a case pending before your court while discussing financial arrangements for your wife. How does that align with your testimony about judicial impartiality? Roberts's mouth moved, but no sound emerged initially. When he finally spoke, his voice was barely above a whisper. That conversation has been taken out of context. The full circumstances. Let's examine the full circumstances, Jasmine interrupted, reaching for another recording. This is a conversation between you and Senator Mitch McConnell, dated October 22, 2023, days before the Morrison oral arguments. The second recording was even more damaging than the first. Roberts could be heard discussing not just the Morrison case, but multiple pending cases with clear political implications. Mitch, I want to assure you that we're taking a comprehensive approach to these constitutional questions. The Morrison case is just the beginning. McConnell's voice, that's good to hear, John. The party needs clarity on campaign finance law, especially heading into the midterms. I understand the political implications completely. We're looking at a trilogy of cases that should provide the legal framework for unrestricted political participation. What about the voting rights cases? Those are more complicated, but I think we can find constitutional grounds for maximum state flexibility in election administration. The conversation revealed systematic coordination between the Chief Justice and Republican political leadership about cases with enormous political consequences. This wasn't judicial independence, it was judicial collaboration with partisan interests. But the most explosive revelation came in a third recording, dated November 5, 2020, the day after the presidential election. John, this is Marcus Wellington. I'm calling about the Pennsylvania ballot case. Roberts's voice, Marcus, I've been expecting your call. The situation is fluid, but manageable. The president is very concerned about the vote counting process. Can we count on the court's support? The constitutional issues are complex, but I think we can find grounds for state legislative authority over election procedures. The key is timing. We need to move quickly before public opinion solidifies. What about the other justices? Thomas and Alito are solid. Gorsuch and Kavanaugh will follow my lead. Barrett is still finding her footing, but she understands the stakes. And if it comes to Bush versus Gore territory? Roberts paused before answering. We need to lose this case, or the party will be finished. But we can't make it look political. The opinion needs constitutional cover. The phrase "we need to lose this case" reverberated through the hearing room like a gunshot. The Chief Justice of the United States Supreme Court had just been caught on tape coordinating with political operatives about election cases while explicitly acknowledging partisan considerations in judicial decision-making. Roberts looked like a man watching his entire world collapse. The lifetime appointment that was supposed to protect his independence had instead enabled his corruption, and now that corruption was being exposed to the entire nation. Jasmine let the silence stretch before delivering her next blow. Chief Justice Roberts, these recordings span a 3-year period and involve coordination with political operatives, corporate litigants, and party officials about cases pending before your court. This isn't judicial independence, it's systematic judicial corruption. She stood up, her movement commanding the attention of every person in the room. You told us that politics, personal relationships, and external pressures have no place in Supreme Court deliberations. But these recordings prove that politics, personal relationships, and external pressures were the primary factors in your deliberations. Roberts tried desperately to mount some kind of defense. These conversations are being grossly mischaracterized. The constitutional principles. What constitutional principles? Jasmine's voice cut through his excuse like a scalpel. The principle that says Supreme Court justices should coordinate with litigants about case outcomes? The principle that allows political operatives to influence judicial decisions? The principle that permits financial arrangements between justices' families and parties appearing before the court? Her questions were devastating because they were unanswerable. There were no constitutional principles that justified what the recordings had revealed. These recordings, Jasmine continued, document systematic corruption of the highest court in America. They show a Chief Justice who has turned the Supreme Court into a political operation serving partisan interests rather than constitutional principles. She gathered her materials methodically, each movement final and decisive. You asked us to trust in the court's impartiality, its independence, its commitment to constitutional law. But the evidence shows that trust has been systematically betrayed for political and financial gain. The hearing room had erupted into chaos. Republican senators were frantically whispering among themselves, trying to figure out how to contain damage that was already beyond containment. Democratic senators were taking notes, recognizing that this was no longer routine oversight, it was the exposure of corruption at the highest levels of American government. But the most significant reaction came from an unexpected source. Justice Elena Kagan, who had been watching the hearing from her Supreme Court office, immediately issued a statement calling for an independent investigation into the allegations against Roberts. Within hours, Justice Sonia Sotomayor and Justice Ketanji Brown Jackson had issued similar statements, effectively isolating Roberts from his own colleagues. The political implications were immediate and severe. By the end of the day, impeachment articles had been drafted by House Democrats. Ethics complaints had been filed with every relevant judicial oversight body. Legal scholars across the political spectrum were calling for Roberts' resignation. But perhaps most damaging was the institutional impact. The Supreme Court's approval rating, already at historic lows, plummeted to single digits. Americans who had maintained faith in their highest court despite partisan divisions found that faith shattered by the evidence of systematic corruption. The recordings were played and replayed on every news channel, analyzed by legal experts and constitutional scholars, dissected in law school classrooms and coffee shop conversations across the country. The phrase "we need to lose this case" became shorthand for judicial corruption, a stark reminder that even lifetime appointments couldn't protect corrupt officials from accountability. Roberts tried to weather the storm initially, issuing statements through Supreme Court spokespersons about mischaracterized conversations and constitutional complexity. But the recordings were too clear, too detailed, too systematically damaging to be explained away through standard political deflection. Within a week, 3 more justices had called for Roberts' resignation. The American Bar Association launched a formal investigation. Congressional Republicans, initially supportive, began the careful dance of political distance as the evidence became impossible to defend. The final straw came when Eleanor Martinez, Roberts' former clerk, came forward with additional evidence of corruption. Martinez had kept detailed records of Roberts' communications and decision-making processes during her time at the court. Chief Justice Roberts didn't just coordinate with outside parties about specific cases, she told a packed press conference. He operated the court as a political institution serving partisan interests. Decisions were made based on political considerations, then legal justifications were crafted afterward. Her testimony provided insider confirmation of what the recordings had suggested, that the Supreme Court under Roberts' leadership had been systematically corrupted, with political considerations driving legal conclusions rather than the reverse. The House voted to impeach Chief Justice John Roberts by a margin of 298 to 137, with 45 Republicans joining all Democrats in supporting impeachment. It was unprecedented in American history. Never before had a Chief Justice been impeached for corruption. The Senate trial that followed was unlike anything in American political experience. Unlike presidential impeachments, where partisan loyalty often trumped evidence, the case against Roberts was built on audio recordings that were impossible to deny or explain away. Roberts' own voice, preserved in digital clarity, provided evidence of systematic coordination with political operatives and corporate litigants about cases affecting their interests. The recordings weren't ambiguous or subject to interpretation, they were explicit documentation of judicial corruption. The most damaging moment came when the Senate played the recording where Roberts discussed losing the Pennsylvania election case, or the party will be finished. The phrase encapsulated everything wrong with Roberts' tenure, the explicit acknowledgement that partisan political considerations were driving supposedly constitutional decisions. The Senate voted to remove Roberts from office by a margin of 74 to 26, with 22 Republicans joining all Democrats in concluding that his conduct was incompatible with judicial office. For the first time in American history, a Chief Justice had been removed for corruption. But the Roberts scandal had broader implications beyond one man's fall from grace. The detailed recordings had revealed systematic problems with Supreme Court ethics and decision-making that went far beyond any individual justice. Congress passed comprehensive judicial reform with overwhelming bipartisan support, legislation requiring real-time disclosure of all communications with parties appearing before the court, establishing independent oversight of judicial conduct, and creating enforceable ethics standards with meaningful penalties. More importantly, the scandal had educated the American people about the importance of judicial accountability in ways that decades of civics education had never achieved. Supreme Court decisions weren't abstract legal principles, they were political choices that affected real people's lives, and those choices needed to be made by judges who weren't corrupted by money and political pressure. The new Chief Justice, appointed after months of careful vetting by a reformed confirmation process, took the oath of office with a commitment to transparency and accountability that would have been unthinkable before the Roberts scandal. Justice Sarah Chen, the first Asian American Chief Justice, spoke directly to the constitutional crisis that had necessitated her appointment. The Roberts scandal taught us that lifetime tenure doesn't guarantee independence, it can enable corruption if proper oversight doesn't exist. My commitment is to rebuild the American people's trust in their highest court by ensuring that every decision is based on legal merit, not political calculation. Her words became a new standard for judicial conduct, quoted in ethics courses and professional standards across the country. The principle was simple but revolutionary: judges serve the Constitution, not political parties. In the months that followed, the Supreme Court began functioning differently. Decisions were accompanied by detailed explanations of the legal reasoning involved. Justices disclosed all communications with outside parties. Financial arrangements were transparent and subject to public scrutiny. The court's approval rating, which had collapsed during the Roberts scandal, began to recover as Americans saw concrete evidence that accountability was possible and that their institutions could reform themselves when forced to confront their failures. Jasmine Crockett, who had triggered the avalanche of accountability with her careful questioning and devastating evidence, found herself once again transformed from a relatively unknown congresswoman into a national symbol of institutional reform. But she rejected attempts to make her a political celebrity, instead focusing on the systematic changes needed to prevent future judicial corruption. In a speech at the National Press Club 6 months after the Roberts hearing, she reflected on what the scandal had revealed about American democracy. The Roberts case wasn't just about one corrupt Chief Justice, she said. It was about a system that had stopped policing itself, that had allowed the appearance of independence to substitute for actual accountability. She paused, her words carrying the weight of someone who had seen how power really worked, but it was also about the power of documentation, investigation, and transparency. When we demand evidence, when we follow the communications, when we refuse to accept judicial mystique as a substitute for ethical conduct, corruption can't survive the scrutiny. The audience, filled with journalists and legal scholars who had covered the scandal from beginning to end, understood that they had witnessed something unprecedented in American politics, not just the fall of a corrupt official, but the successful reform of a corrupted institution. As Jasmine concluded her remarks, she offered a lesson that would echo through American jurisprudence for years to come: democracy doesn't protect itself. Courts don't reform themselves. Justice doesn't ensure itself. All of these require constant vigilance, careful oversight, and the courage to hold powerful people accountable for their actions. The Roberts scandal had ended, but the precedent it set would live on. Future Chief Justices would know that their communications would be scrutinized, their decisions would be analyzed for improper influences, and their conduct would be held to the highest standards of judicial ethics. Most importantly, the American people had learned that even lifetime appointments couldn't protect corrupt officials from accountability when the evidence was overwhelming and the political will for justice was strong enough. Chief Justice John Roberts had begun that hearing as the seemingly untouchable leader of America's highest court. He ended it as a cautionary tale about the price of corruption and the power of truth to bring down even the mightiest institutions. The constitutional crisis had been resolved not by protecting Roberts from scrutiny, but by holding him accountable for betraying the trust that his office required. And in the end, that accountability made the court stronger, more credible, and more worthy of the respect that American democracy demanded from its judicial institutions. The system had been tested, found corrupted, and ultimately reformed. It was a reminder that in America, no one, no matter how powerful, how protected, or how permanent their position, is truly above the law. 33 seconds of devastating audio had led to the most significant judicial reform in American history. Sometimes, that's all it takes to change everything. The Chief Justice who had promised fairness had been exposed as fundamentally unfair. The court that claimed independence had been revealed as politically dependent. The justice system that promised equal treatment under law had been caught providing special treatment for special interests. But through accountability, transparency, and reform, justice had been restored. The Constitution had been preserved. And democracy had been strengthened by confronting rather than ignoring its deepest institutional failures. Roberts's own words, "We need to lose this case, or the party will be finished," became a defining reminder of what happens when judges serve parties instead of principles. And thanks to 33 seconds of devastating truth, that reminder would ensure that future generations of judges understood their true obligation, not to political parties, but to justice itself. But the story didn't end with Roberts's removal from office. The constitutional crisis he had created sent shockwaves through every level of the American judicial system, triggering investigations, reforms, and reckonings that would reshape the relationship between law and politics for generations to come. Within weeks of Roberts's impeachment, investigative journalists had uncovered similar patterns of corruption among federal judges across the country. The Roberts recordings had provided a template for recognizing judicial misconduct, and suddenly, behavior that had once been dismissed as networking or relationship building was being scrutinized as potential corruption. Judge Patricia Walton of the Fifth Circuit Court of Appeals was forced to recuse herself from dozens of cases after recordings surfaced of her coordinating with oil industry lobbyists about environmental regulations. Judge Michael Chin of the Ninth Circuit resigned rather than face impeachment proceedings over his communications with tech industry executives about antitrust cases. The pattern was clear and disturbing. Roberts hadn't been an aberration, but rather the most visible example of a systematic corruption that had infected the entire federal judiciary. For decades, judges had been treating their positions as networking opportunities rather than public trusts, coordinating with interested parties while maintaining the public fiction of judicial independence. Dr. Amanda Foster, a judicial ethics expert at Georgetown Law School, conducted a comprehensive analysis that became known as the Foster Report, a devastating examination of how money and politics had corrupted American courts at every level. What the Roberts case revealed wasn't just individual corruption, she wrote in her introduction. It was institutional failure on a massive scale. The American people had been told for decades that judges were above politics, that lifetime tenure guaranteed independence, that the rule of law protected everyone equally. The Roberts recordings proved that all of these assumptions were false. Her research documented systematic patterns of coordination between judges and political operatives, corporate executives, and wealthy donors that went back decades. The evidence was overwhelming. The American judicial system had been operating as a political and economic institution rather than a legal one. But the most explosive revelation came from an unexpected source, the archives of the Federalist Society, the conservative legal organization that had played a crucial role in judicial nominations for 30 years. When congressional investigators subpoenaed the Society's records as part of their broader inquiry into judicial corruption, they uncovered what amounted to a systematic plan to politicize the federal courts. Internal Federalist Society documents showed detailed strategies for ensuring that conservative judges would rule in favor of business interests, religious organizations, and Republican political priorities. The documents didn't just reveal ideological preferences, they showed explicit coordination between the organization and sitting judges about pending cases. Leonard Leo, the Society's longtime executive vice president, was forced to testify before Congress about what investigators called the Judicial Capture Project. Under oath, Leo was compelled to admit that the Federalist Society had operated as an intermediary between conservative donors and federal judges, facilitating the kind of corruption that the Roberts case had exposed. We saw ourselves as building a judicial infrastructure that would advance constitutional principles, Leo testified, his usual confidence replaced by defensive evasion. Any suggestion that we were coordinating with judges about specific cases, but the most shocking revelation came when investigators uncovered evidence of what they called the shadow docket, a systematic effort by Roberts and other conservative justices to use the court's emergency powers to implement political objectives without full deliberation or public scrutiny. Dr. Stephen Vladek, a Supreme Court expert at the University of Texas Law School, testified before Congress about how the shadow docket had been weaponized. What we discovered was a deliberate strategy to use emergency procedures to achieve political results that couldn't be justified through normal judicial processes, he explained. Important constitutional questions were being decided through unsigned orders issued without oral argument or full briefing, often in the middle of the night when public attention was minimal. The shadow docket had been used to implement voter suppression measures, environmental deregulation, and restrictions on reproductive rights, all through expedited procedures that avoided the kind of scrutiny that full Supreme Court decisions typically received. This wasn't judicial decision-making, Vladek continued. This was political implementation disguised as emergency judicial action. The evidence showed that Roberts had coordinated with Republican political operatives to identify which cases could be fast-tracked through the shadow docket to achieve maximum political impact with minimum public debate. As the scope of judicial corruption became clear, the public reaction was swift and overwhelming. Protests erupted outside federal courthouses across the country, not just against individual judges, but against the entire system that had allowed such systematic corruption to flourish. The signs protesters carried were simple but devastating: justice for sale, courts equals corruption, and most frequently, reform the judiciary now. Maria Santos, a nurse from Phoenix whose union contract had been invalidated by a Roberts court decision that benefited corporate donors, became the face of the reform movement when her speech at a courthouse rally went viral. "I trusted the system," she said, her voice carrying clearly across the crowd and the television cameras. "I believed that when the Supreme Court made a decision, it was based on law, not on who paid the most money to influence the justices." She paused, her composure remarkable for someone whose life had been directly impacted by judicial corruption. "But now I know that when the court ruled against working people, it wasn't because of the Constitution, it was because wealthy donors wanted to crush unions, and they found judges willing to be bought." Her words resonated with millions of Americans who were beginning to understand that judicial decisions affecting their lives had been influenced by the same kind of corruption that they associated with ordinary politicians. The reform movement gained momentum when it received unexpected support from conservative legal scholars who had initially defended the Roberts Court but found themselves unable to justify the evidence of systematic corruption. Judge J. Michael Luttig, a respected conservative jurist and former Fourth Circuit judge, published an op-ed in the Wall Street Journal that sent shockwaves through the legal establishment. "I have spent my career defending judicial independence and conservative constitutional interpretation," he wrote. "But what the congressional investigation has revealed isn't judicial independence, it's judicial dependence on wealthy donors and political operatives who have captured our courts for their own interests." He continued with words that would be quoted in law schools for generations: "The Constitution establishes an independent judiciary to protect the rule of law from political pressure. But when judges coordinate with political parties and corporate interests about case outcomes, they aren't protecting the rule of law, they're corrupting it." The op-ed was particularly devastating because it came from within the conservative legal movement that had championed the judges now revealed as corrupt. When even conservative stalwarts acknowledged that the system had been compromised, the political momentum for reform became unstoppable. Congress passed the Judicial Accountability and Transparency Act with overwhelming bipartisan support, the most comprehensive judicial reform legislation in American history. The law established real-time disclosure requirements for all judicial communications, created an independent inspector general for the federal courts, and implemented term limits for Supreme Court justices to prevent the accumulation of corrupt relationships over decades of service. But perhaps most importantly, the law created enforceable ethics standards with meaningful penalties, including automatic removal from office for judges who violated communication restrictions or failed to disclose financial relationships with interested parties. The first test of the new system came when Justice Amy Coney Barrett was forced to step down after failing to disclose communications with religious organizations about cases involving reproductive rights. The automatic removal provisions worked exactly as intended. Corruption was identified, disclosed, and punished without the need for lengthy political processes. The reformed Supreme Court, with new justices appointed through a more rigorous vetting process, began functioning as the founders had intended. Decisions were based on legal merit rather than political calculation. Justices disclosed all outside communications. Financial relationships were transparent and subject to public scrutiny. The court's approval rating, which had collapsed to single digits during the Roberts scandal, recovered to levels not seen since the 1960s as Americans witnessed concrete evidence that their highest court was finally serving justice rather than special interests. But the most important change was cultural rather than legal. The American people had learned that judicial independence didn't mean judicial immunity from accountability. Lifetime tenure didn't guarantee ethical behavior. Constitutional interpretation wasn't above political influence unless constant vigilance ensured it remained so. Law schools across the country revised their curricula to include extensive training in judicial ethics and accountability. The Roberts Doctrine, the principle that judges must avoid even the appearance of coordination with interested parties, became as fundamental to legal education as precedent and constitutional interpretation. Young lawyers entering the profession understood that they were joining not just a legal system, but a constitutional democracy that required constant protection from corruption and political capture. The scandals of the Roberts era became cautionary tales about what happened when that protection failed. Dr. Elena Martinez, a constitutional law professor at Yale who had clerked for Justice Ginsburg, captured the transformation in a lecture that became required reading in law schools across the country. The Roberts scandal taught us that the Constitution's protections are only as strong as the people who enforce them, she told her students. When judges serve special interests rather than constitutional principles, they don't just corrupt individual cases, they undermine the entire foundation of democratic government. She paused, her words carrying the weight of institutional memory, but the scandal also taught us that corruption, no matter how systematic or well-protected, cannot withstand transparency, accountability, and democratic pressure for reform. 5 years after Roberts' impeachment, the American judicial system had been fundamentally transformed. Corruption hadn't been eliminated entirely, no human institution is perfect, but it had been constrained by transparency requirements, accountability mechanisms, and cultural expectations that made systematic corruption impossible. The phrase "we need to lose this case, or the party will be finished" was inscribed on a plaque in the lobby of the new Federal Judicial Ethics Office, serving as a permanent reminder of what happened when judges served parties instead of justice. Jasmine Crockett, who had triggered the transformation with 33 seconds of devastating audio, reflected on the changes during a speech at the American Bar Association's annual meeting. The Roberts case wasn't just about exposing corruption, she said to an audience of lawyers and judges who had lived through the transformation. It was about reclaiming our constitutional democracy from those who had captured it for their own interests. She concluded with words that had become the new standard for judicial conduct: judges don't serve donors, parties, or political movements. They serve the Constitution, the law, and the American people. When they forget that obligation, it's our responsibility to remind them and to replace them if necessary. The audience, many of whom had initially resisted the reforms that followed Roberts' downfall, applauded with genuine appreciation for what had been accomplished. They had witnessed the near destruction of American judicial independence and its subsequent restoration through accountability and reform. The system had been tested, found wanting, and ultimately strengthened. Democracy had proven capable of reforming itself when citizens demanded better from their institutions. Chief Justice John Roberts had entered the hearing room as the seemingly unassailable leader of American jurisprudence. He left it as the catalyst for the most comprehensive judicial reform in the nation's history. His corruption had nearly destroyed the Supreme Court. But the exposure of that corruption had ultimately saved it, creating a judicial system more transparent, more accountable, and more worthy of the constitutional democracy it was designed to serve. Sometimes, the worst scandals lead to the best reforms. Sometimes, the greatest betrayals of public trust create the strongest safeguards against future betrayal. The Roberts scandal had been a constitutional crisis. But it had also been a constitutional renewal, proof that American democracy, when properly defended, could overcome even the most systematic corruption and emerge stronger than before. 33 seconds of audio had changed everything. And in the end, that change had saved the very system that Roberts's corruption had nearly destroyed.